Mr. Uche Wazroye, a legal practitioner right here in Abuja.
Good morning, Ruth. Congratulations, Human Rights Radio.
Many thanks. I was just waiting for that. And good morning to you, Adana, our in-house barrister.
Thank you, Ruth. Good morning.
Congratulations to you.
Congratulations to you too.
Exactly. I mean, all right. So we are celebrating our very first year anniversary as Human Rights Radio, and so we're just talking about it and we're happy about it. But then it's time for Probono Chambers, where we talk anything and everything legal. Yesterday we had an interesting conversation. It was all about nuisance. What was nuisance? We found out yesterday, what it is, and types, elements, and all that. We will be continuing on a few other things you want to bring out to the knowledge of our listener. You want to do a little recap of what we talked about yesterday?
Yeah, thank you very much. I'm sure a lot of people didn't listen yesterday. They might not be following up if we have to continue from where we stopped yesterday. Today we'll be looking at the defenses and remedies. Yesterday we looked at the meaning of nuisance, to mean exactly conditions or activities or situations that interfere with the use and enjoyment of a particular environment by a person. We also focused on the types of nuisance, to be private nuisance and public nuisance. And yesterday, basically, we said that private nuisance are civil wrongs, so they can only be pleaded in the court of law as a civil wrong in a civil suit. And then public nuisance are criminal, so whatever act you do that interferes with the public, whether it's an action or inaction, that poses as a threat to the public health, public safety, or public morals, it's a public nuisance and it's criminal.
If my neighbor is cooking with firewood and the smoke is entering my room all the time,
not just your room, that of the whole, tenants in the
maybe we're just compound. Two of us. We're just two of us, and
that's private nuisance.
Yeah, and it can cause health risks.
Yeah, health risk.
Okay.
Or, as the case may be.
I mean, it's smoke. It can bring about choking and all that.
Exactly. So we looked at also the elements of nuisance yesterday as to the factors that the courts would consider before granting remedies. We also looked at slightly defenses, and of course we had callers call in and tell us their situations and things they are experiencing that affect them, and they had tagged it as nuisance. Thank you.
Okay, so we will continue with more discussion.
Sure, but it's important perhaps to emphasize that nuisance, as has been described, there's no hard and fast rule about what amounts to nuisance, but there's a standard that determines whether a nuisance has been committed against somebody, which includes any act or conduct of somebody that results to unreasonable and unwarranted inconveniences against another person, that limits his right of enjoyment, or that affects his right to enjoy his own land or occupation. Because when we're talking about nuisance and we're mentioning land, it's not the protection of the interest in land, it's not also the protection of the person who is committing the tort fees, or that is the person who is committing the nuisance, but protection of the person who is in his own land or in the enjoyment of his land. It may not, land here does not mean it must be strictly you are the owner.
Just your space,
where
your
environment, where you're supposed to stay and enjoy. And somebody does something that is that inconveniences you or that causes you annoyance, that interferes with your right of enjoyment of your land. That is a private nuisance. Public nuisance also, as Adana has said, are two categories. There's the criminal aspect of it, there's the tort aspect of it, the civil aspect of it. Public nuisance will constitute a crime, and that one is also actionable by the Attorney General of the state or the federation. Not an individual cannot maintain a criminal action on public nuisance. On public nuisance against the tortfeasor. But it's the same act that constitutes public criminal nuisance, that is a public nuisance that can occasion criminal prosecution. can as well be a basis for a thought. But the challenge about public nuisance when it is a civil wrong is that it is mentioned, it is not something you go to court for simply because you are affected. For you to seek remedy on public nuisance, you must prove that you have suffered a wrong above an ordinary member of the society. That is, the effect of that nuisance on you is greater than an ordinary member of the society. It is upon that that an individual can maintain an action against a person who is constituting public nuisance. And of course, they are they are all over. For example, these things that they do us in Abuja here, once in a while you see a sewage breaking and is not fixed on time, and the feces or other waste products are going about easily moving around and causing inconveniences. These are somebody who.
She reduced saying that. See her face.
Oh, you're looking at my face.
So
I didn't even know I was making
these
that
are
expression.
public nuisances that somebody can take an action against the authority or individual that causes such. But the challenge is that before you can maintain such an action, you must prove that you have an interest above, and such can be established. For example, the source of that break in the maybe sewage system, you may be a resident there. Your inconveniences is greater than somebody who comes there, closes his nose just for a few seconds and passes away.
Yeah.
But the fact that you are living within there, you perceive it constantly, you have a right of action. But an individual who is in his car, some people are very litigation hungry. They say, see this thing, maintain such an action.
Okay, so defenses available for a violator. Yeah, that's part of the things we'll be focusing on largely today.
Perhaps the starting point could be the remedies, and before we go into, because it flows better when we talk about if it has been established that somebody has committed nuisance against you, that is, has inhibited your full enjoyment of your property, and you go to court. What are the things you ask court to do? What are the possible things that court will want to grant you as a relief or as reliefs? And when you have established clearly that your neighbor or another person has caused you great inconveniences that constitute nuisance. So the the remedies available for against somebody who has committed nuisance, and for the benefit of the victim, the person against whom nuisance is committed, is one of them is injunction. The court can make an order restraining the person who used to do that thing that used to constitute a nuisance to his neighbor, or for example, can make an order saying, look, for example, you used to own your generator, and it inconveniences me to the point that I can maintain an action successfully against you. Court can make an order that you will not own that generator again, and if you do, you will not only be punished for damages, the court can commit the person to prison for contempt of court, that is for willful disobedience of court order. Another remedy is.
Sorry, in addition to that, as a plaintiff, if you go to court, seeking for such relief to make an injunctive relief because of the nuisance that have been caused by the defendants, you might make an application for the court to give you an injunction that is temporary pending the final injunction, that is the final ruling of the courts, so that the nuisance will not continuously be happening even while the suit is already in the court. Yes. So you may want to do that.
So in that category, we have three kinds of injunction. We have interim injunction, we have interlocutory injunction, and we have perpetual injunction. Interim injunction is usually granted ex parte, when before hearing the other party. You say, before this thing goes out of hand, can you please, when there is urgency, it's seldom granted these days by courts, but when you can prove that there is a case of that warrants that, before the person is put on notice, any other thing can happen, court can grant you an interim order of injunction against the
That's
person.
good. I think I like that.
Sure. Then another one is what we call interlocutory injunction. This is when the case has been instituted and the other party has been put on notice why the case lasts. Let the status quo be maintained. Don't continue doing that thing. For example, if somebody is doing a construction and he's using heavy earth moving equipment, and the vibration is capable of maybe affecting the integrity of this building, and by the time he submitted the quotation or some other things, either he did not consider that the building like this exists, or the approval given to him did not suggest that he should use such a heavy machine. And you may not, the case may last for 2-3 years in court before the final determination. And if the person is allowed to continue what he's doing, by the time we get to the end of the road, the damage would have been magnified, or the thing you want to preserve may have been damaged beyond the economic repairs or something. So court can grant an order of interlocutory injunction, which is to restrain the tortfeasor, that is the person committing the nuisance, from for continue to do that thing until the case is determined on merit. And once the case is determined on merit, if the party, the plaintiff, is successful, that's, you could have started by way of interim injunction, transmuting to interlocutory injunction. If at the end of the day the person is successful, the court cannot grant what we call perpetual injunction, telling you never again to do it. But if you're unsuccessful, both the interim, of course, interim lapses at the point that interlocutory is granted, and interlocutory lapses at the point final judgment is given. And if you are successful, that interim may now transmute to perpetual. If you are unsuccessful, it goes to no issue any longer. It stops running its lifespan. These are the things about injunction. Then another remedy is damages. Based on the actual loss suffered or imagined loss suffered. And we have mentioned here that in one of our editions that there are two major types of damages: special damages and general damages. Special damages is awarded based on proving facts, proving loss that occasion. For example, in the example we are giving about our house, one construction company comes here and continues to do whatever he wants to do, and this house is certified by Korean, the Nigeria Society of Engineers, for example, that is no longer habitable. The court, if the value of the house is proven, court can award special damages for the cost of either the construction of this house or something like that. You could as well award general damages. In the course of construction, they've been raising dust, and the dust has turned your white shirt to, it was once white.
Now it's
And
brown.
it's now, yes, it's now something more than less than white. So the totality of all these other inconveniences in the eyes of the judge, based on the personal perception or assessment of the judge, that is what is called general damages. Another, well, you can take on now.
All right. Another remedy, it's abatement. This is simply the destruction or reconstruction of a particular thing that interferes with your enjoyment or with your right to comfort of a place. So abatement, you could institute it in the courts, instructing that, or telling the courts that the courts should grant you this relief, where the court will now instruct that, by way of injunctive relief, that such action should be stopped, or you should initiate a particular act that would extinguish such nuisance, as the case may be. Or it could mean self-help, like I stated yesterday, but it should be reasonable. It's not such self-help that could be harmful or that could go by way of violence to affect the alleged violator. Now, yesterday we had a call. We had one of our callers tell us about the roadblocking that happens during religious worship. Now, you could see that, of course, you have a right to freedom to worship in Nigeria, and then you also have a right to passage. You have a right to roads. Now, these rights at this point, are like
They're
against each other. They
conflicting.
conflict themselves, and in such case, quite
They're
Competing
competing.
rights. In law, we call them
yeah.
competing rights.
Yeah, so such persons seeking for remedy, I would not advise you to take self-help, even if you have to notify them before initiating self-help. It's better for you to go to the courts, and then seek for reliefs, such as the abatement I mentioned. Then another remedy available, it's imprisonment or sentencing. We talked about public nuisance yesterday and how it could constitute a criminal offense. Yeah. So you can be charged with the payment of fine or sentencing.
Imprisonment.
Yeah.
Or
Or both, as the case may be.
Wow.
And then before the court, goes further to give these reliefs to the party, that's the plaintiff pleading for it, the courts look at certain factors. They must consider these factors. One of the factors is if nuisance was committed by the defendants. Secondly, if the plaintiff is even entitled to remedy. Then thirdly, they look at how such acts or such actions of the defendant has interfered with the interest of the plaintiff. You may like to take
Sure.
the factors.
In a nutshell, abatement that my learned colleague mentioned, abatement is just asking to return back to status quo. That thing you did wrong, go and do it right. It happens in perhaps in a neighborhood. Your neighbor comes and constructs a gutter that brings his wastewater into your compound or whatever, and the smell and the presence of that water causes you inconveniences, and you go to court and you succeed in action for a nuisance against him. Apart from damages that the court may award against the person, or injunction perpetual, ask him never to do it again. Court can also ask him to abate the nuisance, go and right the wrong you did, go and close that gutter and make sure things return back to status quo. I was getting a little bit agitated when Dana was delving into your right as a victim to go and resort to self-help. Please, we don't advise that here.
No, we don't.
Even though it may look like a remedy available in law, but there are some remedies that are observed better in disobedience by ignoring them, because once you resort,
that is not practicable here.
in practice it's challenging.
It's very challenging.
Because if you do, the person may also resort to self-help, and at the end of the day, two of you may do. It's better to take the right of civilization, the path of civilization, by
Going to court.
That's
or
advice.
right. Get so many times you don't even need to go to court, because when we propose going to court, people think perhaps we are inciting or eliciting. We're inciting people to take. You can, within a community, you can report to maybe if you have an association, you report. They meddle into it. If it is if the person, you can also look for someone that person respects, someone that understands your pains. And maybe some of us, we are too religious. It's only our pastors, our imams that can talk to us, and we believe. And we go and report such things. The most important thing is what you need is a solution to your problem, instead of resorting to self-help. And more importantly, as Adana has mentioned about religious worship or something, like I mentioned earlier, before you can even maintain any form of action against public nuisance, because those ones constitute public nuisance, you must show that you have suffered a loss or pain or inconvenience above an average member of the society. Not just when you park there, you want to.
So what extra thing do you need to prove for when this is the normal road you should pass and then it's blocked because they are praying? What extra? I mean, isn't it obvious?
No, you see,
because even if there's another route, you have to go maybe times 2 or
every
more of that distance.
Every other person is passing through that road and is suffering the level of inconveniences. And
so does it make it right? Because many other people are suffering the same thing. Sorry.
When two rights are competing or conflicting, you understand, equity comes in. Now, mind you that you have a right of access to road. Literally, that road you didn't build it. It's a road provided by state. Where things work well, those religious organizations are licensed. Apart from the license that they have,
but they have a building
for
that purpose.
There are things that are attachment. That is why even in law we took appurtenances. There are things that are incidental to your occupation of a house.
That attachment cannot be on the road.
No. The point we are making
okay,
is
I'm trying to interject because we need to go on a break now.
I wish we can clarify this.
Yes, let's just go on a break. We'll come back on it. All right, so stay with us.
Your right, my right, our right. Everybody's right is protected. Human Rights Radio 101.1, redefining broadcasting.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Probono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
Feature ọ bụ ife eji esi nri, ọ bụ akwa na akpụkpọ ụkwụ, ka ọ bụ akpa ụmụ gị ji eje akwụkwọ na ife iji achọ mma. Gbalubia Halibis Mall, isi ụlọ ngwaahịa anyị dị na +660 Cadastral Zone B1, Franca Febua Crescent Zone E, Apo Legislative Quarters, Gudu District, Abuja. Anyị nwekwara ụlọ ngwaahịa anyị ọzọ na Number 1 Medical Center Road, Maraba, Abuja. Nke ikpeazụ bụ na Number 21 Sariki Meizabo Road, opposite FMC, Kefi, Nasarawa State. Gbaa anyị na ekwentị. Akara ekwentị ị ga-eji nweta anyị bụ 08159 ka mkpọkwa ya n'olu ndị iti 08159510000. Halibis Mall nwere ife niile ị chọrọ n'ofu ebe. Ngwaahịa anyị adịrị ọnụ ma dịrị mma nke ukwuu. Gbalubia na Halibis Mall. Nnọọ.
Human Rights Radio.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Probono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
Welcome back on Pro Bono Chambers this morning on Human Rights Radio 101.1 FM. My name is Ruth, and I've been speaking with Mr. Uche Uwazurunye and Adana, our in-house barrister. Our conversation has been about nuisance, and well, we were at a point that we just had to go on that break talking about public nuisance of road blockage when it comes to.
Sure.
Okay.
I was trying to explain that. Before you can maintain an action, a civil action thought on public nuisance, you must establish that you suffered an inconvenience or loss above an average member of the society. What it means is that if every other person is suffering what you are suffering, you have no right of action against the person. And we were mentioning religious organizations, and I mentioned that about when there is competing rights. And mind you also, your right of access to road is, even though it is a right, but it's also the person has a right, fundamental right to freedom of worship, conscience and religion.
And I said they have a building for it.
Yes, and you said they have a building. We also know that attached to that building or that license to worship, they are attached to that right of worship is also your right to move safely to that place of worship. But somebody, so if you are just an ordinary person, you use that road and every Friday, and you realize it is required of you, because there's a level of tolerance that the law requires you to condone in the course of enjoying your rights. So the law requires you that if you already know that that religious worship center exists and they use that place at that particular time, you should plan your journey in a way that you can use another route, other routes. All you need to is perhaps a little more extra fuel and a little more time. So the law allows that to take place.
Is that not
Moreover, gets you also that, like we talk, but somebody that can maintain an action in that regard could be, and that will take us closely to our the defenses. Now, somebody who can maintain such an action may be somebody who lives there. You understand? You know, yours is will not be allowed to pass, You may have other rules to follow. But this person may be blocked from even taking his children to school. If it's a morning service, for example, on a Friday, or even on a Sunday, you have some other things to do. You could as well be, maybe you are a security officer. That Sunday morning is when you are entitled to
Or
have
there's
a
some
rest.
other emergency,
So also,
health-wise.
or there are other emergency. If your own suffering is above, that is where like residents who are close to such places can maintain such actions. But there are defenses to an action for nuisance. Sorry, some of the defenses is also when you condone it. That is, or the thing has been existing before you packed there. Somebody that can also
But
maintain.
does it make it right?
Somebody that can maintain such an action likely will be somebody who has been there and probably knows that that place originally is not meant for church, and you've been there, and they now suddenly bring church to you, and it's causing you nuisance. You may succeed an action, but if the church preceded your coming, was there before you came, and you now saw the church and you go there, you cannot maintain an action for nuisance, because the defense of voluntary no fit injuria will come in, because you saw the church, you saw its activities and existence before you packed in there. The law requires you that having known that it exists and you go there, you should be able to tolerate whatever inconveniences that may come in the exercise of their own rights.
Anyway, in addition to that, if you maintain an action, you may succeed if you can prove the elements of nuisance. You know, if you can prove that the conduct of the alleged violator, it's unreasonable. You know, it's maliciously, let's say the nuisance is maliciously generated to inconvenience you or to interfere into your right of comfort. Of course, if you maintain an action, it would likely fly.
Okay.
And then if you would, and then if you can also prove that the alleged violator's acts or actions, you know, interferes with your interest in the particular environment.
All right. Well, that's what the law says, and we're here to see what the Lord says, yeah? All right. It's time for you to call in. We open up the phone line now. The number to call is 081-8999-1011. Call in and ask your questions, whether they are about our discussion or about some other legal matters. Hello.
Yeah, good morning.
Good morning. Welcome to Probono Chambers. What's your name?
I'm Mr. Imo on the line.
Okay, please go ahead.
I'm on a radio station.
Yes, it's Human Rights Radio.
Okay.
He just wanted to find out if it was. Okay. It is. But we need people who will contribute and participate. So please call if you're ready to talk. 081-8999-1011. Hello.
Hello.
Good morning. Welcome.
Good morning. This is Shooks from Javi.
Okay, Chooks, you're welcome.
Yeah, I wanted to know, in terms of law, I believe I'm talking to lawyers.
Yes, they are here.
Does the landlord have the right to break into a tenant's apartment, even when the tenant is owing for a year or two, and convert such apartment for another purpose?
Okay. Does
Because,
he?
hello?
Yeah.
Hello?
Yes, I'm here.
Because in answering that question, because even from what we saw from your program this morning, we are apologizing to the landlord. So I want to know, as lawyers in the house, does the landlord have the powers to break into the apartment, convert it, even when the person is owing? Let's assume the person is owing. The person has not paid. Does the landlord have the right to break into that apartment and convert it, or even take away the person's property? Please, let's be clear. Thank you.
Thank you for calling.
Thank you very much. I don't want to discuss a particular life issue because I'm not seized with all the facts. So about somebody that was apologized to, all those things, I'm not sure of the prevailing facts and circumstances. But talking strictly about law, no landlord ordinarily has a right to break into another person's property.
When they are owing.
Sure. One of the rights of a tenant is peaceful and exclusive possession. So once you are a tenant, you have entered legitimately. Even when your tenancy has lapsed by the agreement of the parties, or they are in breach of the terms of the contract of landlord tenancy agreement. Even when you are in breach, the landlord's remedy does not include breaking into your house to take away your things
And
via
converting.
or converting whatever thing he has. So it's generally wrong. It's condemnable. There are Supreme Court decisions about it. I don't want to be citing cases here, so it doesn't
Okay,
look
but simply
very
put,
academic. But simply put,
he doesn't
he
have
doesn't
such
have. But let
power.
me also educate us that a good landlord also has a right to take peaceful possession if he can do it based on the circumstance of the case, and he can do it peacefully without causing loss or damage to the other person. You cannot force him back to the house. For example, you are a bachelor and you are owing, and there's not much inside the room, and the landlord he has been warning you and whatever thing, and notices, and you've not done anything. If he's taking it will cause damage or loss to you, you can sue him for trespass, you can sue him for damages, but where he can do it without incurring any serious liability, he knows you use mat to sleep there, and you just lock it with I pass my neighbor key, 60 naira or 100 naira, and you have been there, he needs his house. If he can quietly take possession and perhaps change the key and repossess the house and put you out, even though he has not taken the normal course of removing you, he may not be found strictly liable. And even if you try to seek redress, you realize that what you may get because as long as it can be established that.
So what's the difference? What's the difference here?
The difference is this.
No,
yes, that's why we are careful about this information. But it's good. Why we must say it is that because we see that some tenants are so wicked that even when they have left, somebody may stay in somebody's house, even pack to his own building, say, let me punish that man. He will lock up the place. He's in another place, or he had traveled abroad. What he left there is something that is of little or no value to him. Whatever happens, he does not care. And the landlord may not have money to get a good lawyer, may not even know the way to go. If you can reclaim possession, because it's your right, without causing loss or damage to that other person, to the tenant, the law protects you. Because if, for example, let us
but now in the instance the tenant had incurred some losses.
He said the tenant is still in his properties. Listen, a situation where the tenant is still in, his properties are there, and like this one that landlords resort to self-help, they go on the roof, remove the windows, remove the doors in order to inconvenience you or induce you to forcefully get out. That is trespass. That is wrong, because they have interfered with your exclusive and quiet enjoyment of the tenement that you rented. And the fact that you are owing is not an excuse for them. They can sue you, and it's important that landlords will also understand that don't even bother always about removing the tenant, because the procedure may look a little bit cumbersome. Sometimes you don't serve notices well or at the appropriate time. You can as well sue that tenant for breach of contract and recover your arrears of rent.
Okay, so in simple terms now, the right procedure for such a situation, what is the landlord expected to do instead of what he just explained to us now?
The landlord is expected to follow the due process of law, which is guided. Well, it depends strictly speaking, his contract. It depends on the terms of the contract. If the tenancy has expired or terminated by inflation of time.
So we are going to assume now that it has expired, just like the caller said.
You serve the tenant with 7 days notice of owner's intention to recover possession. And then after that, you take the person to court and apply for possession, arrears of rent, mean profit, all those.
So anything outside of that is illegal.
If it has not, it is going to expire maybe in 6 months' time, and it says yearly tenancy, there's no agreement to that effect. The person is entitled to 6 months' notice. But if that is the agreement, you have to wait till that time lapses before you can take him to court.
Hello.
Hello, good morning.
Morning, welcome.
My name is Salam Imam.
Okay, go ahead quickly, please.
There were some thoughts around our resting. Actually, we know Sundays we have to make service and we can sacrifice it. But always in the night, in the day, when you came back from work to rest, they will start shouting. They use microphone all the time. And there are sometimes they have some little prayer activities. They are not supposed to use microphone, but they use microphone to inconvenience people in the night. So what do we do about that, or how do we take?
Okay. All right. Thank you for your call. Now that is sound nuisance.
All right. In such case, if he has to go to court as an individual who is being disturbed by the noises of the church, he has to consider so many things. One is, do they actually have a right? Is law permitting them to worship there? That's one. He consider that. Secondly, if he's if he has suffered such wrong or such damages above any other person, living within the environment, he can go to courts and institute an action. But where he hasn't suffered any such damages, he can't institute an action or any civil suits concerning such matter. It's reasonable
If it's
for
giving
him
you
to actually
sleepless nights.
It's reasonable for him to actually give notices to these persons, to see if they can limit such noises that inconveniences him as an individual.
For me, it's a two-edged sword. The course of action arises at the point that noise is above what can ordinarily be tolerated, and the fact we must face it. Most of these religious bodies or churches or mosques don't even have formal licenses to operate. Even beyond all these things we are talking, you see, when we talk about nuisance, even our AEPB law, that is where I also fought them. They don't even enforce what they should enforce, and they neglect what they should. They rather enforce what are negligible. Even beyond in FCT, our Abuja Environmental Protection Law has even gone beyond to codify some of these thoughts and enact them into law, like noise control. That's is when you read the AEPB law, there are things you don't need to do in residential areas. But then,
like having churches in residential
but
areas.
another aspect of it is this, like we said, that will constitute public nuisance, and there are defenses to nuisance, even public and private. One, the issue of condoning, the issue of volunteer not fit injuria. You know that the church, you saw their signboard before you came to rent the house, and you can take judicial notice of it's a notorious fact on how churches operate. And you now just came in there because you are not a member of that denomination, or it's not your own type of religion, and you now want to take an action. When you take them to court may not be able to grant you relief, or maybe as much as you
but
require.
What if, again,
because
they do not
they
have
were
the
there.
right to actually be there because it's a residential area?
See, it's not. You are not. If you are going to court on nuisance, you are not going to question their. It may be a fact that court may consider.
Won't that come up eventually?
Yeah,
Perhaps
if-
say, okay,
if
in
it-
the first place, they are not even supposed
Then
to be
One of
here.
the factors the court may consider
it
before you're
may,
granted
yes,
a relief.
it may come up, but when it comes, what we call local standard will come in.
Okay, I really would have loved for us to come to a conclusion on this conversation, but perhaps we may have to revisit it another time. We have to go now because infomercial will be coming up next, another program right here. So sorry about that. We may have to just continue
Do these
this another
defenses
time.
next time. Wow.
But many thanks to you for trying to explain so many of these things to us and to our listeners too. I see that the calls are still coming in, but we have to make way for infomercial right here on Human Rights Radio 101.1 FM. Thanks to Mr. Uche Wazroye for being here, and also to our in-house barrister Adanna.
Thank you very much, Rose.
And many thanks to you, the listeners. We'll do this again tomorrow, God willing. Same time, same station. Stay with us.
Join our diverse team of